Blava & Co Solicitors, committed to excellence.
Hi, my name is Harpreet Gundara and I'm a Housing and Civil Litigation Solicitor at Blava & Co. I would like to take this opportunity to remind, if not inform, private landlords of the changes that the Localism Act, which has amended sections 213 to 215 of the Housing Act 2004 and that received royal assent on 15th November 2011, shall bring to the tenancy deposit scheme in particular. Now, private landlords must be ready for the forthcoming changes to avoid severe penalties for non-compliance. Now, just to let you know what the previous position was before I talk about the changes that the Localism Act has brought. Previously, under sections 212 to 215 of the Housing Act 2004, landlords were penalised for not properly securing deposits. Under those provisions, the landlord or his agents were required to comply with the initial requirements of a tenancy deposit scheme within 14 days of receiving a deposit and giving the tenant any prescribed information required by the scheme. Failure to do so would require a landlord to pay up to 3 times the deposit monies back to the tenant, and furthermore, under sections 215, it would invalidate a section 21 notice and prejudice other applications for possession, for example, section 8 possession proceedings based on rent arrears. Therefore, any section 21 notice issued and any proceedings based on such a section 21 notice were technically invalid. However, if the landlord subsequently protected the deposit after proceedings were issued, it has not been clear what the court's powers were in relation to the validity of these proceedings. The courts have been faced with deciding whether to interpret the requirements of the tenant deposit scheme strictly, thereby meaning that if a landlord did not comply with the scheme within 14 days of the deposit monies being received, ordering the landlord to pay 3 times the deposit to the tenant and preventing the landlord from ending the tenancy by his own initiative through a 2 months notice, regardless of how minor or how unintentional the breach was, or maybe taking a relaxed approach but thereby rendering the legislation ineffective. Therefore, decisions such as Draycott & Draycott versus Hennells Lettings Limited, Tiense versus Vision Enterprises Limited, and Gladehurst Properties Limited versus Farid Hashimi sought to soften the impact of the penal element of the legislation, requiring a landlord to protect the deposit before a hearing date in order to avoid punishment, and also that the landlord does not have to comply with the deposit requirements once the tenancy has come to an end, as it only applies to current tenancies. Now, the above decisions determined that a tenant could not bring a case for the breach of the tenancy deposit scheme if the landlord has placed the deposit into a tenancy deposit scheme prior to the court hearing, even if it is outside the 14-day time period. These cases, however, have now been superseded by the Localism Act 2011, and the new rules apply even to concluded tenancies. Now, the most significant changes that have been brought by the Localism Act 2011 is that the time period for complying with the initial requirements of a scheme and providing the prescribed information has been extended from 14 to 30 days after receipt of the deposit. The penalty will be payable if the landlord fails to comply with the time limits imposed by statute. Therefore, it's an absolute time limit of 30 days within receipt. The landlord will also no longer escape liability for the penalty if he or she complies with the requirements before the day of the hearing of the tenant's claim for the penalty. A person who was the tenant will be able to bring a claim for the penalty. The Localism Act has therefore reversed the decision in Hashimi versus Gladehurst. The penalty will not necessarily be equal to 3 times the amount of the deposit and will not be in addition to the court ordering the repayment of the deposit or that it paid into the scheme. The amount of the penalty will be at the court's discretion, but no more than 3 times the amount. The restriction of the service of the Section 21 notice has also been removed where the deposit has been returned in full or else returned less any agreed deductions, and if a tenant has brought a claim, that claim has been either determined by the court, withdrawn or settled. If a tenant does apply to the county court once the tenancy has ended, the landlord will not be able to retrospectively pay the deposit into a scheme but must repay the deposit or part of it to the tenant. Furthermore, any Section 21 2 months notice terminating the tenancy will not be valid unless compliance has taken place. Section 125 of the Housing Act 2004 will be amended to confirm that a Section 21 notice may not be given where a deposit has not been protected within the 30-day period, but if the deposit has been returned to the tenant in full or with such deductions as has been agreed, or an application has been determined by the county court or the proceedings withdrawn or settled, then a Section 21 notice may effectively be served. A landlord therefore cannot put the the tenancy deposit into an authorised scheme on day 31, or advise the tenant of the prescribed information until after day 31 and later serve a Section 21 notice. This therefore may mean that so long as a tenant does not breach the conditions of the tenancy agreement, a landlord may never be able to take possession of their property. The new legislation therefore means fairer and more proportionate action will be taken against landlords who fail to comply with the new provisions. Hence, landlords should be wary of the Act and the new governing rules coming into force in or around April 2012 to avoid the aforesaid penalties and court action from their respective tenants.